The broadcast is now starting. All attendees are in listen-only mode.
Good morning and good afternoon, everyone. And I hope you and your families are all well and safe. Firstly, I'd just like to thank you for joining us today, particularly at a time when we're all juggling priorities and facing new challenges every day. Unfortunately, Richard Heald, our CEO, hasn't been able to join us today, but we're going to continue as usual. My name is Meghna, and I lead on the healthcare and life sciences and digital innovation sectors here at the UKIVC. And I'll just run you through some of the basic stuff about the webinar before the presentation. So this is just one in a series of webinars that we're doing. We have done some in the past on insolvency and bankruptcy code in India. We've done one on the labour and employment laws in India and another one on the high value food market, all of which are available on our website. So, if you want to just go onto our website and have a look at what other webinars are there, please do look at that. Going forward, we are constantly working to identify issues that are impacting our members and other companies. So we can run similar events and activities to answer any questions or any difficulties that you have. So if you are interested in subscribing to our newsletter, which not only gives you an idea of what we are doing, the activities, but also our forthcoming events, please feel free to go onto our website and you can register your interest there to receive our newsletter. On the slides, you will see the Twitter handles for both the UKIVC and the IPO. So if you've got any questions at any point after the webinar, you can obviously write to either myself or Pragya, who's our main presenter today. But can I also say that this session will be recorded and uploaded onto our website tomorrow. So if you're not taking notes, you're just listening in, please feel free to just listen and you will have all of this on our website tomorrow. And in terms of sending questions, if I can just request everyone who has any questions to send it through the text box, which should be on the right-hand corner of your screen. I will just collate all of these questions and then put them onto Pragya at the end of the presentation. Just to set the scene a little bit, I just wanted to say that the UKIVC and IPO going forward, we will be working very closely to look at the IP regime in India. So, in the past, having interacted with some of you and other companies, we have realized that IP has been a challenge for certain companies, not just protecting IP, but also commercializing, and hence we're sort of joining hands with the IPO, and this is first in a series of projects that we will be doing. So with the webinar is one of the things. Following this, we will still be reaching out to you if you've got any specific IP related issues. And then, sort of making that engagement, whether it's connecting you to the right people or sort of, working with the governments and both central and state in India to flag some of these issues. So going forward, can I just request all listeners to go on mute so we don't have any background noise? And I will then briefly introduce Pragya. Pragya Chaturvedi, who has recently joined the IPO team as an IPO attaché. She's based out of the British High Commission in Delhi. And while representing the IPO, she works very closely with the Government of India in strengthening the IP regime in India. And before joining the Intellectual Property Office, Pragya worked with the National Law University and Copyright Office in India. So Pragya's got bags of experience within this area. So over to you, Pragya, for just a brief introduction of the Intellectual Property Office and of course your presentation.
Yes, thank you so much, Meghna, for the introduction, and thank you for hosting this webinar. It's a pleasure to be here and a pleasure to be able to connect to everyone who has joined in. Very good afternoon to everyone, and good morning to our listeners from the UK. I hope everyone is staying safe and staying home. Um, we are going through some very challenging times, which hopefully will pass soon. In the meantime, as life must go on, I would like to start the discussion by outlining the areas we are going to broadly cover today. So, as you can see, we are going to cover the importance of IP protection, the help that you can get in India in protecting your IP, the latest IP developments that have taken place in India, particularly in the last 5 years or so. And then we are going to talk a little about something that is on everyone's mind right now, and that is the impact of the ongoing pandemic on functioning of the IP offices here in India. So functioning of offices all over the world has been impacted, and IP is not untouched by it. I would like to reiterate that this interaction will be successful with everyone's participation, and I encourage you to ask as many questions as possible. As the UK IPO's attaché here in India, I'm here to answer your questions and provide all the IP support that you need to do business here in India. So coming to our first point of discussion, why is IP protection important? How does it help your business? What happens if you don't register? And what can happen if your rights are infringed? First of all, IP as an umbrella term, we use it to denote various types of intangible property. For example, patents, trademarks, copyrights, industrial designs, and so on. They are different because of the subject matter that they protect and the threshold requirements for granting of protection. So IP can help you and your business in more than one way. First of all is the competitive economic advantage that IP offers your business. With IP protection, you get the right to exclude others from making unauthorized use of your IP or making any unauthorized distribution of your protected IP. Second is differentiation. IP serves a very important function of differentiating your product or service from the products or services of your competitors. Let's take an example to understand this. For example, you go to the store to buy your favorite brand of soap. Then how do you recognize which is the soap that you want to buy? It has to be the packaging, the logo, the particular color that the branding uses, and that is how you differentiate it from other products that you don't want. So that is one very important purpose that IP serves, differentiation. If your IP is not protected, it leaves your business open to risk because others can then misappropriate your intellectual property. It also allows your business to generate revenue. If you have intellectual property, you can assign it to others, you can enter into licensing agreements, and then you can it allows you to generate royalty and monetize your IP. It also eliminates the risk of other people free riding on your innovation, your creativity. So it protects your hard work that way. Another important part to keep in mind is once you have lost your right, it's kind of very difficult to get them back in. So it's important to ensure that your IP is protected. If you enter into legal battles without protected IP, it can be very expensive, very time consuming, and which is something that you may want to avoid. Then IP protection also gives you some non-economic advantages. For example, in case of patents, you have the right to be mentioned as an inventor, the right to assert your ownership over the patent. Similarly, in the case of copyright, you get some moral rights that are associated with your copyright. Then, depending on the type of IP, you have criminal and civil remedies available for violation of your intellectual property. So IP is often the most important asset for a business, especially in today's world, which thrives on innovation, creativity, and technology, and yet is often underprotected. So it's very important to know and to protect your IP. Coming to IP protection in India, there are basically broadly 7 types of IP that are recognized globally, and they're also recognized in India. So we will start with trade secrets and confidential information. When we talk about trade secrets and confidential information, there is often a fine line of difference between the two. All trade secrets are confidential information, but not all confidential information is a trade secret. While there is no single definition which we can attribute to confidential information, as a general guideline, confidential information has to be commercially valuable. It has to be protected by taking reasonable steps to ensure its confidentiality. For example, if you just leave, a document containing confidential information just lying about, it doesn't really warrant protection. Then it has to be communicated to the receiving party in confidence. This part is important because the other party should have clear understanding that they are not supposed to disclose the information that they're receiving in confidence. And last but not the least, the information should not be in public domain. Otherwise, it will not be considered confidential information. Now, in order to be classified as trade secret, the confidential information should be able to provide a business an edge over its competitors. That is the particular part that differentiates confidential information from trade secret. So a trade secret can be a manufacturing secret, a commercial secret, an industrial secret, a client list, or a marketing strategy, an advertising strategy, and so on. For example, I'm sure everyone will be familiar with the top secret recipe of Coca-Cola. That is one trade secret. So there can be many benefits of protecting information as confidential information. For example, the protection that you get by protecting your information as confidential information or trade secrets is virtually unlimited, as it ends only when the information becomes public, it comes out into the public domain. Also, since confidential information and trade secrets, they can be protected through non-disclosure agreements, which is a relatively inexpensive way of protecting it. So that way you have certain benefits of protecting information as confidential, but at the same time, the protection that it offers is limited. Because if someone develops that information independently or without inappropriate access to your trade secrets, then the protection is no longer available, and which is not the case with patent law. In patent law, independent innovation is not a defense. So coming to patents, patent is an exclusive right which is given to the inventors of an invention. It allows them to prevent others from using the invention without permission, which is the case with most types of IP. And subject to a few exceptions, a patent may be granted for an invention or an improvement, which can be in the case of, for example, a device, an apparatus, a method of using the invention, a process for making an invention, or a product produced by by the process of invention. In India, we have a certain threshold requirement for granting a patent, which is usually tougher than other forms of IP. So we call it the patentability criteria. And in order to be granted patent, the invention has to pass all these three criteria. So the first one is novelty, the other one is inventive step, and the third one is industrial applicability. Novelty means that the invention that you want to patent must be new, not previously disclosed, should not be in public domain. For example, if you claim to invent a washing machine, that is not exactly new. But if there is an improvement, for example, in the technology that is used in the washing machine, that may qualify as a patentable invention. The next patentability criteria is the um, non-obviousness. Non-obviousness means that the invention should not be obvious to the person having ordinary skill in the relevant art. That is a term used by courts to determine if the invention would be obvious or would be familiar to a person who has reasonable familiarity with the terminology and the technical knowledge in the field. So if an invention is obvious to a person like that, it will not qualify as a patentable invention. Then there is industrial applicability, which is very different from marketability. So the threshold of industrial applicability exists so as to prevent granting of patents to frivolous inventions. It means that the product should have some kind of utility. Um, some kind of industrial application, but that is very, very different from marketability. Even if the product doesn't have a demand in the market, it doesn't mean that it does not have an industrial utility. So we have to make a distinction there. Even a product with zero demand can have some industrial applicability, some industrial utility, and pass the threshold of patentability. Okay, so there are certain provisions in the Indian Patent Act which list many non-patentable inventions, and these grounds of prohibition for certain inventions, they are broadly based on grounds of public policy. For example, a computer program by itself is not patentable. A method of doing business is not patentable. Only the discovery of a new form of an already existing substance is not patentable. A combination of known devices, a method of agriculture, a method of playing games, or any literary, artistic, musical work, basically any work that is copyrightable, any traditional knowledge, any topography of integrated circuits. These are some examples of specifically prohibited inventions under the Indian Patent Act, which are specifically not patentable, or any inventions relating to atomic energy, again on public policy grounds. So this is about an overview of the patent system in India. Once granted, patents last for 20 years from the date of filing, after which they come out into the public domain. Next is trademarks. So a trademark can be any word, any symbol, sound, or even a smell, which is used to differentiate a product or service from its competitors. So the main purpose of a trademark is differentiation, but it can have some other functions also. For example, trademarks can serve to indicate the quality which a customer can relate to a goods and services of a particular brand. They can also serve to avoid consumer confusion by acting as a mark of identification, as I just mentioned. So there are different types of marks, which then determines their strength and then their registrability with the trademark office. So first up is arbitrary and fanciful marks, which have absolutely no relationship to the product or the characteristics of the products. They don't describe the products or its uses or purpose in any way. For example, Apple for computer, or Maytag for appliances, which, these words have absolutely no relationship with the product itself or its characteristics. These types of marks are the strongest and have higher chances of registration. Then there are suggestive marks, which do not exactly describe the product, but they suggest the nature or characteristics uh, of the product. And while there's no direct relationship, but still an inference can be drawn as to the characteristics of the product. For example, Pathfinder. Pathfinder by itself doesn't suggest an SUV vehicle. That is the name of an SUV vehicle made by Nissan, but by itself it doesn't suggest. It does suggest something that is off-road, but doesn't really suggest any relationship to a four-wheeler. Then there are descriptive marks. Descriptive marks typically identify attributes of the product, such as the purpose of the product, the origin of the product, so on and so forth. By themselves, they're not very strong, they're not very likely to get registered, and to qualify for protection, they must acquire a secondary meaning. For example, there's one very popular example of Jiffy Lube, which describes a vehicle oil, which is very quick acting, but it has also acquired a secondary meaning in the mind of the consumers, and that way it can qualify for protection. Another example would be a surname incorporated into a mark. For example, McDonald's, Hilton Hotels. These are also names which have acquired a secondary meaning in the minds of consumers, and that is why they would qualify for protection. Then the last one would be generic marks, which are not distinctive and they do not qualify for protection because they are not capable of distinguishing one brand from another. For example, it's not permissible to use the word mark milk to brand a milk product, something like that. These are the marks which have become generic and they cannot be appropriated as they belong to the public at large. So coming to the types of marks that are protected in India. So the trademark registry in India has different categories of marks that they recognize. First is the word marks. For example, PNG retail, that is just the word that is registered. Then there are device marks which denote logos. Then there are service marks which are not very different from a trademark. The only difference between a trademark and a service mark is that service marks represent services instead of goods. For example, Singapore Airlines or Virgin Atlantic. Those would be service marks. Then there are collective marks, which denote a group of people who use it to distinguish their quality and services. For example, we have the Institute of Chartered Accountants here in India, and that logo of Chartered Accountants, the C Institute, it denotes a group of people, these particular Chartered Accountants, and that is known as a collective mark. Then we have certification marks, which indicate the quality of a product or service. For example, the ISI logo, which certifies that a product is of a particular quality. So these are the marks which are used in the conventional sense. We have, as I mentioned earlier, we have some unconventional marks. For example, sound marks. So these are the sound marks which the listener can associate to a particular brand or a particular business or service. For example, the Nokia theme tune, the Yahoo Yodel, that was the first sound mark to be registered in India. Then we have smell marks, which are very, very rare because you can only register smell as a mark if the smell does not arise from the character of the product. And that way it can be very, very difficult to even explain. And that's why smell marks are very, very rare. Then we have the color trademark, which reminds you of a particular product or particular brand. For example, the blue color from Tiffany or the purple color from Cadbury chocolates. So those are color marks. Then there are shape marks, which identify shape of a product, which can distinguish a product from others. For example, there was the Coca-Cola bottle, which had a particularly distinctive shape, which distinguished it from other soft drinks in the market. And those are the marks that qualify for protection as shape marks. Then we have copyrights, which protect creative works, any literary work, printed material, artistic works such as logos, paintings, maps, drawings, and so on. Then we have music, the graph music, recorded audio, movies, and so on. So in India, the threshold generally the threshold for copyright protection is originality, and by originality we mean that the work itself should originate from the author, that is the person creating it, and it should not be copied from somewhere else. And depending on the work, the term of protection varies. Usually it's 60 years. In case of movies and sound recordings, it's 60 years after publication. For other works, it lasts for the lifetime of the person who creates it, who is the author, and it lasts for 60 years after that death of the author. So it's lifetime plus 60 years. Um, After that, we have industrial designs. So industrial designs protect the ornamental and visual aspects of an industrial article, which are visible to the eye. And this does not include the functional design. So, for example, if a design serves a functional purpose, then it is not included in the scope of industrial design. It only protects the ornamental aspects. For example, the design of a bridal gown, or the ornamental patterns on a crockery set. Those are the types of products protected by an industrial design. Then we have some other less common forms of IP. Uh, One is plant variety protection, which is granted for different varieties of plants. And another one is integrated circuits, which is granted for the layout design of the microchips, which are usually used in computers. But that's not very common. There have only been 2 registrations so far, so that is not very much in use. We also have geographical indications which serve to distinguish products originating from a particular geographical territory. They need not necessarily be named after that particular geographical territory, but they have certain characteristics, certain quality, which can be associated to products that are produced in that particular geographical area. For example, Scotch whiskey, or coming to India, we have Alfonso mango, we have Pashmina, we have the blue pottery of Jaipur, we have a particular type of alcohol that is produced in a certain part of India. So these are the products which carry certain quality or certain characteristics which can be attributed to the particular geographical region that they are made in, and that is why we call them geographical indications. So that is it about the types of IP protection in India. When you need help to protect your IP. Um, First off, in the British High Commission, as the attaché, as I mentioned earlier, I work very closely with British businesses to provide them any support, any assistance that they need with IP issues in India. We also work very closely with the Indian government to strengthen the IP system in India. And I frequently engage with British businesses. I answer their questions on the IP landscape, different questions that they might have on the IP regime in India, on the IP registration in India. Other than that, we have the guidelines available from the Indian IP office, which is frequently updated on their website. Then we have the Cell for IPR Promotion and Management, that is a Government of India body, and they do a lot of work with respect to IP awareness. And the British High Commission, the UK IP office, we work very closely with CPAM. So these are a few resources that you can refer to when you need help protecting your IP in India. Another very good, very useful resource is the UK IPO's country guide for India, that is available online on the IPO's website. If you need any specialized help, for example, in cases of litigation, we have some specialized IP law firms in India. We also help by working very closely with the with different industries, with different businesses. We also hold stakeholder engagements. We then present the issues that industries are facing to the government, and we hold regional dialogues, bilateral dialogues, so that everyone can come together at the same place and then lay out their issues on the table. So that is how we work. Coming to the latest IP developments in the region, a lot has happened in the last 5 years. It has been transformational for the IP landscape. In 2016, India got its first IPR policy, which clearly defined the objective as stimulating the generation of IP, placing more importance on IP commercialization. And one thing that has been a little problematic in India, which is the enforcement of IP and the long time which takes in adjudication of IP, and the IPR policy defines strengthening the enforcement and adjudication system as one of its objectives. Then India has also ratified certain international treaties, for example, the WIPO Copyright Treaty, WIPO Producers and Phonograms Treaty. There are certain international classification systems, for example, the Locarno Agreement, which is used in case of industrial designs. There's a NICE agreement in the Vienna Agreement that is used in case of classification of trademarks. So India has ratified to all these treaties very recently in the last 2 years. Then another not so good news is India has pulled out of the RCEP, the regional comprehensive economic partnership negotiations. This means that stronger IP protection in the form of extension of patent term or data exclusivity protection, they are off the table for now. But another good development is the introduction of commercial courts through the Commercial Courts Act, which recognizes IP as a commercial matter, and which also provides for compulsory mediation, and it also provides for a time frame based adjudication and resolution of matters, which can lead to more timely resolution of IP disputes. So that's good news on that front. When it comes to enforcing your IP in India, the police has certain powers, for example, some search and seizure powers under certain acts. Then, depending on the type of IP, you have civil and criminal remedies available. In case of patent law, geographical indications, trade secrets, industrial designs, plant varieties, you only have civil remedies available, which are injunctions, damages, and accounts of profit. In case of copyright law, trademark law, and integrated service, you have both civil and criminal remedies available. So criminal remedies translate to imprisonment of the violator and fine or fine. So this is the judiciary route that you can take in case of violation of intellectual property. Then in case of customs, the customs now have a dedicated website through which you can record your IP rights with the customs authorities, so that if there is import of any IP infringing product, they can put a stop to it right there and not release the consignment. We at the UK IPO are also collaborating with the customs authority to do more work in this area, and sometime soon, hopefully, we'll make an announcement in that regard. What you can do to make sure your IP is protected is to register your IP first and foremost, then make use of non-disclosure agreements in case you have some confidential information or trade secrets to protect. I will again reiterate that I'm, as the IPO's attaché, I'm available to provide all the support in every way I can. For specialized support, you can approach the IP law firms, which are here in India, and it's important to take advice of legal professionals in case your IP conflicts with someone else's IP. It could be, you may also consider changing the IP in case of a conflict like that. And last but not the least, designating a responsible person within your business to take care of your IP matters. So the last part, the impact of COVID-19 on registration of IP is that the IP offices for now are not functioning. They have deferred all the hearings that were scheduled till a later date. Um, uh, so it has it has some likely impact on registration timelines, definitely, but I don't believe that there's any need for panic, because the government is expected to take certain steps which protect the interests of the right holders and not make them unnecessarily suffer. So yeah, that is it. Thank you, everyone. Thank you for joining in, and thank you for listening. And any questions, please direct them to me.
Thanks, Pragya. That was a very good presentation. So thanks not just for the presentation, but also offering your support to companies who may wish to engage with you later. We've got some questions here. So, first of all, we've got someone who's asking, are criminal remedies available in India for trade secret violation?
No. First of all, India has no specific law for trade secret protection, but Indian courts have provided trade secret protection under various statutes, for example, contract law and common law principles. So as of now, there are no criminal remedies available for breach of trade secrets, only civil remedies under common law.
Thank you. I've got another one, and they're asking, at what stage of the business do we address the IPO? Any recommendations on the steps to engage with an Indian-based business to protect ideas and business plans? And they say that they have not had positive experience in 2018, but they're not giving up yet.
Okay. So when collaborating with other businesses, it's advisable to ensure IP protection before you engage into any kind of collaborative arrangements with other businesses. Because once you have IP protection, then, as I mentioned, you can exclude others from making use of your IP. And before engaging with other businesses, you need to make sure that your IP is protected from any kind of misappropriation or misuse.
Thank you. There's another question which talks about the IP enforcement. So how is IP enforced in India, and does enforcement vary depending on which administrative division the IP falls in? I know you briefly touched upon the powers and who does what, but can you just elaborate a little bit more on that?
Yes. So in engaging with different British businesses, I have come across these problems that businesses have with enforcement, especially with piracy and counterfeiting. But yeah, depending on the legislation, as I mentioned, the nature of remedies differs. So in case of patent law, GIs, trade secrets, industrial designs, and plant varieties, civil remedies are available. These civil remedies are injunctions. Injunction is basically an order which you can get to stop someone from making use of your IP. In certain cases, you also have the remedy to recover the information from the person who is misusing it. Then you have damages, which is kind of a compensation for the loss you have suffered as a result of misappropriation of IP. Then you have accounts of profit, which is given in lieu of damages, and that is also kind of compensation, and that depends on how much the other person has profited from making use of your IP, and then you're compensated accordingly. And then in case of copyright, trademark, and integrated integrated circuits, along with the civil remedies, you have criminal remedies, which is imprisonment for a certain term, and which increases if it's a repeat offense, and the fine also, which increases depending on the circumstance. So it depends on the governing act rather than the administrative division, the remedies for the enforcement that are available.
Great, thanks. Here's an
Yeah.
interesting one. With the government of India coming up with quite a few new schemes, particularly for startups. We've got someone asking if UK businesses or foreign businesses qualify for the benefits under the Startup IP Protection Scheme.
Not that I'm aware of. As far as I'm aware, this is a scheme for the benefit of domestic businesses and to promote IP filing and protection for domestic businesses. But one good thing from that scheme is that the government of India has empaneled a role of trademark agents, patent agents, and other attorneys, and it's there on the Government of India website. It's also available. It will soon be available in our country guide also. So these people are qualified intellectual property professionals who are empaneled by the government, who other businesses, foreign businesses, including UK businesses, can also approach in case they need any help with filing of their IP, or for example, attending hearings in the trademark or the patent office.
Great. This is an interesting one. This is from the Cardiff Met University, and what they're asking is if it is possible for them to collaborate with on any IP research for their international Indian students who are studying in the UK. I think this might be something that perhaps this person can probably just write to you, Pragya. Do you think that might be better, or there's something you want to share at this point?
Yes, I think this is something that the person asking this question can get in touch with me directly, and I can definitely help with that. But this warrants a longer discussion. So yeah, that would be very helpful if you can get in touch with me directly, and then we can have a discussion on this.
Sure, and Pragya's email ID is on the slide, which is on the screen right now. The next one is, what would be your top 3 tips for companies entering India for securing their IP?
Okay. So the first one is to make sure you register your IP. That's a given. There are some IP rights which are for which it's not compulsory to register, but it's still advisable. For example, in the case of trademarks, in the case of unregistered trademarks, you have the remedy for passing off available, but in case of violation of your trademarks, there's a higher burden on you to prove that someone has engaged in passing off, to prove that someone that your business has suffered as a result of that passing off, and to prove that your business has suffered a lot of harm, and that you have been using that trademark previously. In case of a registered trademark, you have a remedy of infringement available where you do not have that burden of proof. Similarly, in the case of copyright, if copyright registration is completely voluntary, it's not mandatory. Copyright comes into existence as soon as the copyrightable work is created, but registering your work with the Copyright Office then provides you with a prima facie record of your work, which you can then use to prove ownership of your work. Another one would be, and that's a very important part, to engage in an FTO search. FTO is the Freedom to Operate search, which ensures that the product that you're bringing in here in India, or to any other country for that matter, does not infringe upon someone else's IP right. And in case it does, then you can consider other avenues. For example, purchasing the IP that you're incorporating in your product or service, but is infringing upon someone else's rights, or engaging in cross licensing, or any different avenues. But basically, the purpose is to make sure that you don't engage into infringing someone else's IP, and you have the freedom to operate in that particular area. Another would be the third tip would be to take help from legal professionals, and from all the resources that are available online on the UK IPO's website as well as the Indian IP Office's website, because they regularly publish some very useful guidelines which are particularly helpful for the applicants. From my time in the Copyright Office, I'll give you the example of the examination guidelines that were issued. Before that, there used to be a lot of confusion amongst the applicants, and then it resulted in frequent objections within the applications that were filed. But after the examination guidelines were issued, they were of particular help to the applicants, and from my interactions with different businesses, it actually helped them a lot. So those would be my top 3 tips.
Fantastic. I think that was one of the questions that I wanted to wrap it up with, but anyway, we can do that at the end. I've got one more question which talks more in terms of what's happening right now with COVID-19.
Yes.
What are the implications with regards to deadlines for deadlines and cost of payment, cost of patent review?
Okay. So the Indian IP office, I think for last 2 weeks or so, almost every day they have been issuing a lot of notices, a lot of guidelines, and the gist of all that is that since the hearings are rescheduled, some hearings are cancelled, there is going to be a definite impact when it comes to the timeline of registration. But the Indian government is expected to take certain measures which make sure that the right holders do not suffer if there is any delay, for example, in submission or transmission of requisite documents because of this particular situation, then it doesn't affect the right holder in any adverse way. And then there is a condonation of that delay regarding this specific situation. There was a notice uploaded on the website of the Patent Office which specifically dealt with that, and they specifically mentioned that any delay because of this COVID-19 pandemic will be condoned provided the applicant makes an application. So that is one thing, one very important aspect to remember. If you for certain reasons are not able to submit the documents in time, you have to make an application for condonation of that delay. Same is the case with the Trademark Office.
Great.
So
thank you. I think we've got a few more questions, but they may be more sort of one-to-one engagement. So what we do is we'd encourage companies to either get in touch with Pragya if there are specific IP related questions, or just drop me an email. Both our emails are on here. So, just to sort of summarize, I think, Pragya, you've done it quite well, and I'll just put it in sort of as short a summary as possible, is the key things to take away is register your IP, you engage in an FTO search, just to ensure that your product doesn't infringe on any other copyrights anywhere else in the world. If it does, then you may have to look at alternatives. And of course, Pragya has very kindly offered to support any companies who are looking to sort of do business in India, particularly on the IP side. And of course, there are other resources available on the IPO website in the UK and also the Indian IP office.
Right, Meghna.
Brilliant. So can I thank you very, very much, Pragya, for this presentation. For me, it was really, really useful. I'm sure companies have found it useful as well. We encourage everyone to send us some feedback and of course questions to either of us. And just to remind everyone that this webinar was recorded, so it will be available on our website tomorrow. So please feel free, if you've missed out on anything, then you can go and get it from there. Thank you so very much for your time.
Thank you. It was an absolute pleasure. Thank you.
Thank you, and stay safe, everyone.
Stay safe. Yeah.